In a stunning and unanimous 9-0 ruling, the Supreme Court has sent shockwaves through American constitutional law. The decision, delivered in a packed courtroom and broadcast across the nation, has already sparked intense debate and reflection among legal scholars, policymakers, and everyday citizens alike. This verdict fundamentally reshapes the delicate balance between personal privacy, national security, and the ever-expanding power of corporations in our digital age. It's a moment that will be studied for generations, as it redefines the boundaries of what information can be accessed, stored, and shared. The case, United States versus Digital Sentinel Alliance, has become a pivotal moment in our history. It's not just another legal battle, it's a turning point that will influence how technology and law interact for decades to come. Its implications reach far beyond our borders, setting a global precedent for digital rights. Countries around the world are watching closely, as this ruling could inspire similar debates and reforms internationally. At its core, the decision answers a question that has challenged lawmakers for years. How do we apply centuries-old protections to the limitless world of the internet? The court's response bridges the gap between the founding principles of the Constitution and the realities of modern technology. The justices, in rare and remarkable agreement, have fundamentally altered the landscape of data collection and surveillance. Their ruling sends a clear message: the rights of individuals must evolve alongside technological progress. This is more than a legal adjustment, it's a redefinition of what it means to be a private citizen in the digital era. For millions, it's a reassurance that their personal data is not simply up for grabs. The case pitted the federal government's call for broad data access against privacy advocates and tech companies defending individual rights. The courtroom became a battleground for competing visions of freedom and security. The journey to this verdict forced a national reckoning with the trade-offs between convenience, security, and freedom. It challenged Americans to consider what they value most in a connected world. The court's unified voice shows these principles transcend political divides. In this moment, the justices stood together to protect the core values that define our democracy. Tonight, we'll unpack the history, the legal questions, and what this ruling means for your rights as an American. We'll explore how this decision will shape the future of privacy, technology, and the law. The era of unchecked digital data collection has met its most formidable challenge yet. The Supreme Court's decision marks the dawn of a new chapter in the ongoing struggle to balance liberty and security in the digital world. This landmark case began not in the halls of Washington, but in the heart of Texas, with a small but ambitious Austin software company called Innovate Forward. What seemed like an ordinary day would soon spiral into a legal battle with national consequences. The company's IT team, while performing routine checks, discovered unauthorized data quietly leaving its servers, an anomaly that set off immediate alarms. The data, encrypted and almost undetectable, was traced back to a federal intelligence contractor, raising suspicions of something far more serious than a typical cyber attack. Innovate Forward, with no government contracts or classified projects, initially sought a straightforward injunction, believing they were victims of corporate espionage or perhaps a rogue competitor, but the Department of Justice intervened unexpectedly, invoking the rarely used state secrets privilege. They revealed that the data collection was not a random breach, but part of a vast, secret surveillance program authorized under the Digital Privacy and Sovereignty Act of 2022. What started as a private lawsuit over data theft quickly escalated into a direct and public challenge to the federal government's surveillance powers and secrecy. The DPSA, passed with overwhelming bipartisan support, was originally intended to shield Americans' data from foreign threats. Yet, hidden clauses within the law permitted sweeping domestic metadata collection, far beyond what most lawmakers or the public realized. Privacy advocates had long warned of these dangers, but even they were shocked by the scale and scope of the government's secret program, which touched millions of unsuspecting Americans. In response, civil liberties groups and major tech companies, some of the biggest names in Silicon Valley, formed the Digital Sentinel Alliance, joining Innovate Forward's fight and bringing unprecedented resources and attention to the case. The case rapidly became a national referendum on the DPSA and the government's secret interpretation of its own powers, dominating headlines and sparking heated debate across the country. The alliance argued passionately that collecting millions of Americans' metadata without individual warrants was a clear violation of the Fourth Amendment's protections against unreasonable searches and seizures. The government, however, insisted that such measures were absolutely necessary to protect national security and prevent potential threats, refusing to back down. The stage was set for a historic constitutional showdown, with both sides preparing for a battle that could reshape the future of digital privacy in America. What began as a local dispute in a small Austin office now threatened to rewrite the rules of digital privacy and government surveillance for the entire nation, affecting every American who uses digital technology. As the case reached the highest courts, the eyes of the world turned to the United States, waiting to see how the balance between privacy and security would be decided. The case's journey through the courts was a legal marathon. The government tried to block public scrutiny, citing national security, but the district court ruled the constitutionality of the surveillance program must be debated. This was the alliance's first major victory. On appeal, the Fifth Circuit was split, with 2 judges upholding the government's position and 1 writing a powerful dissent. The dissent argued that the scale and intimacy of digital data made old privacy doctrines obsolete. This dissent became the foundation for the Supreme Court appeal. Recognizing the issue's national importance, the Supreme Court agreed to hear the case. The question: does the Fourth Amendment protect the vast digital metadata of Americans in the age of the algorithm? At the heart of the case was the Digital Privacy and Sovereignty Act, or DPSA. Publicly, it promised data protection and cybersecurity, but Section 702B authorized intelligence agencies to collect domestic metadata in bulk. The government claimed metadata, like call logs and browsing history, wasn't protected content. The alliance countered that metadata reveals intimate details of our lives, often more than the content itself. They argued that warrantless collection of this data was like assigning a government agent to follow every citizen. During Supreme Court arguments, the government warned of blinding our watchmen, while the alliance likened the program to tracking every letter mailed in the country. The justices pressed both sides on the limits of government power in a digital world. The stakes for privacy and security had never been higher. On January 27, 2026, the Supreme Court delivered a unanimous decision against the government. The majority opinion declared Section 702B's mass metadata collection unconstitutional, calling it an unreasonable search under the Fourth Amendment. The court rejected the outdated third-party doctrine for the digital age, recognizing that digital life is not a voluntary surrender of privacy. The ruling creates a new standard. The government must obtain a warrant to access an individual's digital metadata. This doesn't dismantle national security tools, but requires targeted, warrant-based use. The decision forces Congress to rewrite surveillance laws with stronger protections. The 9-0 verdict is a constitutional reset for the digital era. The court's unity sends a clear message: digital privacy is a fundamental right. The landscape of American privacy law has changed forever. The political fallout was immediate and impossible to ignore, sending shockwaves through the corridors of power in Washington. Lawmakers who supported the DPSA now face intense scrutiny and mounting calls for oversight, as both the public and the press demand accountability for their decisions. The Supreme Court's ruling is a sharp rebuke of both executive overreach and legislative carelessness, signaling a new era of checks and balances. Privacy has surged to the forefront of the national conversation, becoming a central issue for upcoming elections and forcing candidates to take clear, public stances on data protection and civil liberties. Civil liberties advocates are newly empowered, seizing the moment to push for stronger protections, while national security hawks scramble to adapt their strategies to the changing legal landscape. The intelligence community now faces the daunting task of overhauling its practices, shifting from broad mass collection to more precise targeted surveillance methods that comply with the new legal standards. Globally, America's allies praise the ruling as a significant step forward for human rights, while adversaries watch closely for any signs of weakened U.S. intelligence capabilities. European leaders see the decision as a long-awaited alignment of U.S. law with their own strict data protections, easing transatlantic tensions and paving the way for deeper cooperation on digital policy. The geopolitical ramifications are just beginning to unfold, with analysts predicting far-reaching consequences for international security and diplomacy. The U.S. must now recalibrate its entire security apparatus to operate within this new legal reality. balancing the demands of national defense with the imperative to protect individual rights. Around the world, people and governments alike are watching closely to see how America navigates the delicate balance between liberty and security in this new era. The conversation about digital rights has gone global, sparking debates and inspiring movements for privacy and freedom in countries far beyond U.S. borders. The Supreme Court's decision has rocked the tech industry. Companies now have a powerful legal shield to reject broad government data requests. But the ruling also brings new compliance challenges and potential lawsuits over corporate data practices. Data brokers' stocks have plummeted, while privacy-focused companies are surging. The era of surveillance capitalism is under threat, and business models may shift toward privacy-first approaches. Innovation is now centered on user privacy, with new companies marketing themselves as Supreme Court compliant. The economic landscape of the internet is being redrawn. Those who adapt to this privacy-first world will thrive in the coming decade. This ruling changes how Americans relate to technology and privacy. For the first time, digital lives are granted the same privacy as physical ones. Citizens now have legal grounds to demand more control over their data. The decision is expected to spark digital literacy and awareness, teaching new generations about their rights. It strengthens free speech and association by curbing dragnet surveillance. But reclaiming privacy requires conscious effort, reading policies, adjusting settings, and choosing privacy-respecting services. The Supreme Court has opened the door to a more private digital future. The fight for digital sovereignty is just beginning. Its impact depends on how we, as a society, choose to use this new tool. The unanimous decision in United States versus Digital Sentinel Alliance closes one chapter and opens another. Congress must now rewrite surveillance laws to comply with the court's mandate. The ruling sets a powerful precedent for future cases involving technology and privacy. Lower courts will apply these principles to everything from facial recognition to smart devices. The Supreme Court has drawn a bright line for digital privacy. For Americans, vigilance and engagement are essential to defend these rights. The 9-0 verdict proves the Constitution can adapt to new realities. Liberty and privacy remain essential, no matter the technology. The conversation about digital rights is vital to our democracy. The future of privacy is now in our hands.